colocándolo ahí. ¿Me escucha, Juan? Ok.
Good morning, 257.
Mr. Philippe.
Good morning.
Good morning, Chris. How are you?
Just fine, and I hope you're well.
Good, thank you. You too. Chris, are we good for a tiny extension on this to continue to do discovery?
How many days?
I mean, probably a month.
Sure.
Thanks, Mr. Philippe.
As long as your client doesn't waste my client's goods.
No, certainly not.
We can probably just tell Estella what we need.
Good morning, Estella.
Good morning.
How are you?
Just fine, and you?
Very
Y'all
good,
wanna-
Mrs. Elias.
You all wanna reset?
That would be awesome, Mrs. Stella.
Okay, how much time did you all need?
Like 30 days?
Yeah, 30 days, give you enough time. Yes, I think that would be fine.
Thank you, Chris.
Let's see, let me look at the calendar. The 24th will work if for us.
Okay, is there any way, and that's like right in the middle of this tiny little thing,
Yes.
early voting.
That's true.
It's the tiny,
Yes,
tiny
yes.
thing.
Well, why don't we do it then after? Let's do. What about, let me look at the. What about
Good
the
morning.
10th? March 10th?
That sounds phenomenal.
Mr. Felipe?
I think that'll probably be all right.
Thank you so much, Chris.
Okay, and I don't know if the judge is there already. Cindy?
Yes, he is.
Okay, just let the judge, let's see what the judge says, but March 10th would, works for us.
At 8
Morning,
o'clock-
Cindy.
Good morning.
At 8 o'clock again?
Yes.
So will that be by Zoom or in person?
I don't know, Mr. Philip, right now. We're taking a month by month, a week by week.
Good morning, Rick. How are you?
I have another matter I'd like the judge to consider setting for me for tomorrow's docket.
Okay, the judge is gonna be taking the bench pretty soon. Hold on,
Right now.
right now, okay.
You're muted, Judge.
Good morning, everyone.
Morning, Judge.
Morning, Judge.
The 107th will call its court into session today for today's docket, Monday, January 24, 2022, starting with civil hearing 2021 DCL 5654, Martinez Escamilla.
Good morning, Your Honor. Erin Gomez on behalf of Ms. Escamilla.
Morning. Good morning. What are we doing with this one?
We're asking for a reset, Your Honor. Chris Lee for the movement. And so it's giving us a date of March 10th at 8 o'clock.
Is that okay with everybody?
Yes, Judge, please.
Okay. March 10th it is.
Your Honor, that's all I have. May I be excused?
Yes. Thank you, Ms.
Thanks,
Connolly.
Judge. Hope everyone has a great day.
Thank you.
You, bye-bye.
Judge,
Yes, sir.
Christopher Lee, I've got a client in jail that we've completed all the papers for and everything's ready to go. I wonder if I can have a court date tomorrow, perhaps, to free him out.
Well, why don't you call me, Ms. Solis on the line?
Not yet.
Ms. Salas,
Yes, sir.
why don't you talk to Mr. Felipe about, Ms. Felipe, why don't you call me Salas and we'll get you a date for that or confirmation for that, okay?
Yes, Your Honor, thank you.
Thank you. All right. 2021 DCL 6210, Juan de Dios Osuna, Adelante Funding, Mr. Nunez, Mr. Aguirre.
Good morning, Your Honor. Rick Nunez on behalf of the plaintiff.
Good morning, Your Honor. Carlos Izaguirre here for defendant Adelante Funding.
All right.
Judge,
Well-
this is a continued hearing. We had requested that the temporary restraining order become a temporary injunction on this case. We had filed it prior to a foreclosure that was scheduled by the defendant on property owned by my client, the plaintiff. So we're ready to proceed. And Judge, what this is for my client, the stakes couldn't be higher. At stake is not only his livelihood, but his homestead, his residence, and his business location as well. It's his principal asset. It represents a lifetime of his work as an auto body repairman. My client is now 75 years of age. He's on the screen and present in the virtual courtroom. This case was filed after there was a suit between these same parties back in 2017, and that suit claimed an illegal home equity loan that was disguised as a commercial loan. The matter was settled at mediation back in 2017. It was June the 30th, 2017, which is the date of the MSA. At that time, the $200,000 commercial loan at 15% was renegotiated to a $57,000 loan at 6%, with payments at $735, with payments of $1,345 a month per the loan documents. And there's a snafu because that's not consistent with the MSA. The MSA indicates that the loan is going to be for $51,000 with payments of $1,198. And there was some renegotiation after the MSA. Judge, the current market value of the property, which is on Old Port Isabel Road, is $425,000 according to my client. The tax valuation is $316,000. And we have filed an exhibit list. They are exhibits A through H. And on that exhibit list, there are some notices that were sent to my client in advance of the posted foreclosure. On the notices, it indicates that there is a balance due of $40,723. That's the notice that went out on October the 8th. But there's a notice that went out a month prior on September the 9th of 2021, which indicates a balance of $54,704. There is shown on the September notice that there is forced placed insurance in the amount of $1,132. But there is now an indication with the exhibits that were filed by the defendant that the forced place insurance premiums that they're seeking reimbursement of is the amount of $4,869. There's discrepancy with regard to the balance. There's discrepancy with regard to the forced placed insurance. The MSA indicates that the forced placed insurance is going to be for liability insurance only. That's right in the MSA. So I've got an issue as to whether the forced placed insurance was truly liability only insurance and what the amount is. At any rate, there is so much discrepancy, even among the very notices that the defendant sent out, that this case needs to be litigated. The amount of the balance, if any, needs to be determined. And I have, in my exhibit list, I showed every payment that was made by my client. And there are 48 payments because that's exactly what the modified loan called for. Every payment is there. In fact, my client has paid a total of $64,873.83. That's the compilation. It's my exhibit G. And it is a compilation of each and every timely payment that my client has made. The amortization schedule on a $51,000 loan at 6% shows that he should have paid a total of $57,491. So this isn't a delinquent defendant who has failed to make his his payments. There's some true discrepancy here. Now, there's some issue with regard to some paid taxes, taxes that were paid by the defendant and added to the mortgage loan, which the law certainly allows. But that amount is at issue as well. At any rate, Your Honor, what I'd ask, because of the extreme equity in the property, there is no harm that will come to this defendant by setting this case for trial, allowing us to do some discovery. But in the meanwhile, we'd ask that the court issue a temporary injunction enjoining the defendant from foreclosing upon the property while we do that discovery. And the reason I say there's no harm that'll come to this defendant is because this defendant is a secured creditor, and the value of the asset at stake is at a minimum the tax valuation of $316,000. But again, my client is prepared to testify that the fair market value is $425,000, and this on a claim. And there's a payoff that the defendant has filed. We have each filed our exhibit list. The defendant's exhibit, which is D8, indicates that the payoff, at least as of November the 15th of last year, is the amount of $41,174.17. And that is a moving target, because the balance here has been hard for me and certainly for my client to ascertain, given the contradiction in the very notices. But at any rate, we have an exhibit now post filing that of my petition that shows that there's a balance of $41,000. And for that reason, it's our position that this defendant will not be in any way prejudiced with a delay in time and a temporary injunction while we get this matter resolved. And for that reason, Your Honor, we'd ask that the court grant the temporary injunction and set this case for a trial after sufficient time to do some discovery.
Mr. Zaguirre, Mr. Zaguirre, I don't mean to cut you off in your presentation, but I need a little brief narrative because I want to come back to you all in a bit, so I can let you, state your obvious positions that Mr. Nunez has. But I want to make sure I want to take care of the rest of the docket, because then I have a law between the last item and my criminal docket, and I want to be able to use that time to hear you out slowly. Can you please indulge me and let me move on to my other docket? I'll come back to you, okay?
Yeah, yes, sir.
All right, thank you. All right, let me call the rest of the docket. 2021 DCL 6475, Jose Alvarez and Miriam Fernandez Sosa. Mr. Estamil.
Good morning, Your Honor. We're ready to proceed when the interpreter.
Alejandro, are you there? Okay. Where is Mr.? Oh, there. Mr. Nevadas, can you unmute yourself? Alejandro, can you interpret?
Señor Robert, por favor, se puede quitar se puede desmudecer, por favor.
Mr. Nevadas?
Señor Navarres. Señor José Navarres.
La computadora, no se oye nada.
Tiene el icono del micrófono que está a la izquierda. Oprímale ahí, por favor.
Ándele.
Thank you. Okay. Raise your right hand, please.
Levante su mano derecha, por favor.
Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
¿Jura decir la verdad y solamente la verdad? ¿Lo jura usted por Dios?
Sí.
Yes.
Thank you.
Gracias.
Put your head down.
Your name
Levante su
is
mano, por favor.
Proceed.
Your name is Jose Narvaez, is that correct?
Su nombre es José Narváez, ¿correcto?
Sí.
Yes.
And you're married to Miriam Fernandez Sosa?
Miriam Fernández Sosa es su esposa?
Sí.
Yes.
And you got married on or about 2014?
¿Aproximadamente se casaron ustedes en el año del 2014?
Sí.
Yes.
And you separated on or about May 2019?
¿Y aproximadamente en mayo del 2019 fue cuando se separaron?
Sí.
Yes.
And prior to filing for this divorce, you lived in Texas for 6 months, Cameron County in 90 days.
Y antes de llevar a cabo la demanda de divorcio, ¿había usted residido en el estado de Texas por 6 meses y tan siquiera 90 días en el condado de Cameron?
Se le cortó, disculpe, se le cortó.
Antes de llevar a cabo la presentación de esta demanda de divorcio, ¿había usted residido en el estado de Texas por 6 meses y tan siquiera 90 días en el condado de Cameron?
Antes de,
Antes de.
no, yo viví en México.
I lived in Mexico.
You lived in Mexico 6 months before you filed for, 3 months before you filed for the divorce.
3 meses antes de la presentación del divorcio, ¿había estado viviendo usted en México?
No,
No.
Where did you live?
¿Dónde vivió usted?
en Los Trenos.
En Los Fresnos.
All right. And has your marriage become insupportable because of conflict of personalities that destroys the marriage relationship?
Su matrimonio ha llegado a tal grado de insoportabilidad por conflicto de caracteres que afecta la legitimidad del mismo matrimonio, ¿correcto?
You don't
Sí.
get along.
Yes.
And you have no children born during this marriage, is that correct?
No hubo producto de este matrimonio, ¿correcto? ¿No tuvieron hijos dentro del matrimonio?
No,
No, no.
And no children expected or adopted?
¿Ningún niño adoptado ni en camino?
no,
No.
And do you have any community property?
¿Tiene patrimonio conyugal? ¿Tiene algún bienes raíces, una casa, algo, etcétera? No.
Do you have any community debt?
¿Tiene deuda patrimonial?
no, tampoco.
No, neither.
And you're asking for a divorce?
¿Y está solicitando divorciarse?
Sí.
Yes.
That's all you're.
Es todo,
We'll
señor.
take official notice of all documents and file.
Se toma conocimiento judicial de todos los documentos presentados en el expediente.
Court will find that it has jurisdiction by virtue of the domiciliary requirements of the family code.
Se resuelve ahorita en este momento que sí se tiene jurisdicción, comprobando todo la jurisdicción en relación a los domicilios.
Discúlpeme, es que se le cortó, discúlpeme.
Oh, I'm sorry, it got cut off. Se toma conocimiento judicial de todo lo presentado. Se toma conocimiento judicial también en relación a la jurisdicción.
And the court, having heard the evidence of petitioner in support of his divorce petition, hereby grants it.
Y de acuerdo al testimonio que escuchó este juzgado, por parte del solicitante se otorga este divorcio.
And approves the division of the assets as stated on the record by Mr. Navarez.
Y se aprueba la división de los bienes de acuerdo al testimonio del señor Narváez.
All right, anything else, counsel?
¿Algo más?
Okay, thank you, gracias, thank you.
Entonces, ya es todo lo que tengo que hacer.
That's all I have to do?
Yes, sir.
Sí, señor.
¿Ya puedo colgar?
Yes.
I can log off?
Yes, sir.
Sí, señor.
Muchas gracias, muy amables todos. Que tengan un buen día.
Thank you very much. Have a great day.
Give me a second before I call the other one. Okay. I'm out at work. I'm doing my docket. It's a long one.
Cindy,
Yes.
he did say the 107, right?
Yeah.
And did you get my email
Yes.
on the, okay, great.
All right, sorry. Let me continue with 2022 DCL 146, Baron, Salazar, Mr. Garza, and Mr. Sanchez.
Judge Noe Garza for Ms. Barron.
Dan Sanchez for Mr. Salazar.
Your Honor, I
Yeah.
filed a protective order on behalf of Ms. Barron. I understand Mr. Sanchez was just recently retained, I think over the weekend. And he is requesting an extension of the protective order. As long as Mr. Salazar adheres to the protective order, temporary protective order, we would have no objection to an extension.
That's correct, Your Honor. I just
Right.
got hired. I need some time.
All right, how long do y'all need?
You can give me about 3 weeks, Judge. So I need to get some information together as
All
well.
right. Ms. Salas,
Let's set it up for February 14th.
no.
Oh,
I don't want to see Mr. Sanchez with the Valentine stuff all over here or Mr. Garza either, because I know they're slaves to that holiday for sure.
Absolutely.
All right. No, that's the first day of early voting, so I'm gonna be busy. So I gotta tell you,
Okay.
I'm not gonna be holding court, so I'd rather do it another day.
okay, and the following week, Judge?
The week
Oh.
before,
No,
I mean-
I don't. What's going on here? Is this something that needs immediate attention from me in terms of hearing the merits of this matter, or is it something that can and has been controlled by the temporary protective order?
Judge, will agree that the temporary protective order extend until whatever date
Okay.
that you no longer are occupied, and my client will adhere by it.
Mr. Garza, any problem with that?
just as long as he's admonished that that protective order has teeth and that he needs to adhere to whatever this court issued temporarily.
Who are we talking about?
Mr. Salazar, I
Are you-
represent.
Are you Mr. Salazar? He is the subject of this protective order?
Yes, Your Honor.
Mr. Sanchez, do you have any problem with me asking, is that your client?
He's there, Judge. It says Amber because it's his daughter's laptop, but it's Mr. Daniel Salazar.
Can you hear me, Mr. Salazar?
Yes, sir.
All right, hey, let me ask you something. Have you had an opportunity to go over what is required of you temporarily while we hear this matter with your counsel, Mr. Sanchez?
I have, Your Honor.
All
Yes.
right. You feel you've understood every single provision that is and regarding that it's required of you?
Yes, sir.
Okay. And I hope that you don't have any problems adhering to that temporarily until we get to the bottom of this. And I'm going to try to set it as soon as I can.
That's fine.
To get
Thank
to
you.
To get them to the merits of what's going on here. Okay.
I appreciate it.
All right. So Ms. Salas, give me a date after the 25th, the following week,
Okay, let's set it up for the 28th.
the 28th. All right.
28th of February, Judge?
Yes, sir.
That works.
And I don't know if it's going to be contested. I want to make sure I have time for you guys. So do you foresee this? Well, I know I can't put you on the spot, Mr. Sanchez, but well, how are the winds blowing over there?
Judge, I think that once I get all my stuff together and get with Mr. Garza, this will probably end up being an agreed order that we can nail out.
Okay. All right, then we'll see you on the 28th.
Okay.
All I have, Your Honor.
Thank you, Mr. Salazar.
Thank you.
That's all I have, Your Honor. May I be excused?
Yes, sir. Have a good day.
You
Well,
too, Judge.
All right. Let me get back to Margarito Osuna and Adelante Funding. All right. Mr. Aguirre, you were about to give me your response to Mr. Nunez's contention.
Yes, Your Honor. Thank you. The biggest problem I see with what Mr. Nunez is saying, Judge, is that there are amounts under this loan agreement that are admittedly owed. There's taxes and there's insurance, both of which the loan documents say Mr. Ozuna is responsible for. And if Mr. Ozuna does not pay property taxes, or if he does not pay for the required insurance, then the lender, my client, can go ahead and advance those funds. And those will be tacked onto the principal, which is exactly what's happened in this case. I have filed exhibits evidencing the amount of force-placed insurance that was paid for by my client and the amount of property taxes that were paid by my client, dating back to the 2017 taxes. So my client has paid 2017 taxes, 2018 taxes, 2019 taxes, 2020 taxes, and now, if history repeats itself, we're going to be responsible for paying the 2021 taxes as well. Under fundamental principles of equity, a debtor seeking equitable relief from a foreclosure sale must first tender the full sum of the admitted debt. So what we've got here is Mr. Ozuna has failed to pay the taxes and he's failed to pay the insurance. Those are amounts that are admittedly owed on the debt. There's no way around it. I mean, the contract is very clear that those amounts are admittedly owed. So before he can come to your honor and ask for and obtain a temporary injunction, he's got to pay those amounts. And that's all we're asking for, Judge. And you know, we've been back here several times now. This has been reset several times over the past several months.
You're asking that they pay
the opinion
4,000 and change for the forced insurance. Is that what your records show?
The records show about $4,800, almost $4,900. You know, that amount's increased a little bit since the last setting, but it's about $4,900, Judge.
And then the insurance is what is it? I mean, the taxes. What is the amount for each year?
According to Exhibit 10, Your Honor, we've got total taxes of $30,171. It's about between $7,000 and $7,700 per year.
Is the forced insurance, according to your documents, a liability insurance, or is it a general liability?
That I'm not sure about, Your Honor. My client would have to testify to that. But I'm glad that you brought that up, Your Honor, because there's another issue that I wanted to address in my opening, and that is the concept of novation. Mr. Nunez cited a mediated settlement agreement settled several times. That mediated settlement agreement was superseded by a loan modification agreement that was signed after the mediation. So we had the mediation. I wasn't involved in that proceeding, Your Honor, but these two parties had a mediation. They came to an agreement. They signed a quick and dirty agreement there at the mediation, but with the understanding that they would follow it up with a formal loan modification agreement. So that's exactly what they did. Mr. Nunez himself drafted the loan modification agreement, and the loan modification agreement says the promissory note and deed of trust that were originally signed way back when are still in force and effect. Current with 21 CC. And the terms of those agreements, the terms of the promissory note and the terms of the deed of trust are only altered by the loan modification agreement. So the loan modification agreement, you know, doesn't require that the insurance be only liability insurance. I mean, it's just the insurance that's required under the deed of trust. So that's really the document that we need to look at when we're talking about what insurance is required. But regardless, even if
let me ask. Hold on a second before you leave that subject. Let me ask you. So if the mediated settlement agreement does have that limitation on the insurance that it only be liability, what was left to be done after the MSA was entered was a modification of the documents that regarding the loan amount and the principal and all those things. And so now you're saying that the fact that those documents that were prepared by Mr. Nunez contain no limitation of what kind of insurance. Delante went and bought all types, different types of coverage that were more suited and more advantage or more, I guess, liking to advantage Adelante funding than what would be contemplated in the MSA. Is that correct?
No, Your Honor. So
Did you buy more expensive insurance covering more things other than liability when you did do the forced insurance? How far off did you go from that? What coverage did you add to the forced insurance that was not contemplated by the MSA, which you now maintain has been modified through this loan renegotiation agreement?
my understanding is that the coverage was just a basic lender's policy, Judge. So if the building burns down, we don't lose our security. We get the amount of the loan back. And I think the way those policies are written, it's whatever the amount of the payoff is at that particular time. So if the payoff was $40,000, that's what the policy would be for. It doesn't protect Mr. Ozuna. It protects.
It protects your debt. It protects. It's like credit life insurance. You know, the life of the person protects the debt. When you pass away unexpectedly in the middle of the loan gets paid by the insurance.
Yes,
Something
sir.
like that. I understand that. So,
Judge, if I
well,
can,
but see, hold on, Mr. Nunes. But see, that's where I'm trying to say. So your insurance premiums are correlated to the amount of the debt. Is that that's what you just told me, right? Your premium, how much they charge you, is based on how much is owed to you.
I believe that's true, Your Honor.
All right. So that in a sense is a moving target if that balance year after year, or how does that work? See, what I'm trying to figure out is contemplating Mr. Nunez's contentions that this loan balance is a moving target. Where and when was the insurance assessed, on what balance and when and what date? That's a question that comes up to my mind. Okay, well, if it's a moving target in that sense, in the one you just described, Mr. Izaguirre, and he maintains that the balance has been in this loan has been an issue from ab initio, that you really don't know what is owed and why. Yeah, they've had several balances. Now, you may think there's no merit to that, but that's what I hear Mr. Nunez saying. So obviously you take issue with that's not true, that has been a consistent known balance from day one. Am I right?
You're right in that we do know what the balance is, but more important, Judge, we know the amount of the taxes down to the penny. Even if there was an issue with the insurance, which I don't think there is, but
I think you're right about that. I think you're right about that the taxes they are what they are. They're not based on any they have nothing to do with it. The debt is just the valuation, appraisal district valuation of the land and the building or whatever. It has nothing to do with a debt.
Well, it does have something to do with the debt, Your Honor, in that those taxes are owed by Mr. Ozuna.
Well, in that regard, it does. Yes, I agree with you. That your agreement, whether BMSA or modified, subsequently modified, they all contain the obligation of 1, maintaining insurance, 2, paying their taxes. I'm aware of that.
And that's the only reason, Judge, that I cited the Ginther Davis Center versus Houston National Bank opinion earlier, saying that in order for a debtor to get an injunction to stop a foreclosure sale, that debtor has got to pay the amount that he admits he owes. So, you know, in order to receive equity, you have to do equity.
Well,
so He's got to pay those amounts that he owes before he can get an injunction.
I agree with you, but what if you're wrong on only one of those issues, Mr. Izaguirre? Just assuming with me for argument's sake, you're wrong on the insurance amount, that the insurance was not properly calculated according to the debt or whatever. So that adds more debt to the principal. That's number one. Number two, the taxes have nothing to do with that. The taxes, they are what they are. But in the final analysis, when they talk about principal amount that includes taxes and everything owed, there has to be a consistent, known balance where the debtor knows exactly what he has paid and what he has not paid. Now, you have provided, I hope, a detailed accounting of all the payments that he's made and everything that has been, how it's been credited to his account and when it was credited, because to a certain extent, if you're incorrect about the insurance, that's going to throw the number off in your accounting principle. It has nothing to do with the taxes. The taxes are given, they have nothing to do with it other than what you just said, that because it's owed as part of the debt. But it has nothing to do with that because those are assessed based on completely different things. So those are owed. They are set figures that you have. This debt has nothing to do, has not affected it, has not changed it, has not modified it. Those are assessed by a totally different authority based on valuation of the property. Now, it is his obligation to have paid those taxes. That's a contractual obligation. I agree and I understand that. So at the very minimum, this is an accounting situation. Are you in fact giving out the right balances to the debtor for whatever reason? But you're telling me that before I get there, I need to have him tender to you the taxes that you have paid.
That's what the Ginther Davis Center opinion stands for, Your Honor, just that before he can obtain an injunction, he's got to pay those taxes at a minimum.
Mr. Nunez, did you favor me with that copy of that opinion, Mr. Izaguirre? I know I have the file here. I have a lot of filings.
I can file it, Your Honor.
Can you please, I would like to see it and I would like to read that.
Yes, sir.
If you don't mind. Mr. Nunez.
Judge, I take issue with the fact that, with the statement that the amount of the payoff is a known quantity. It's not even known to the defendant. I mean, we have two statements, one in September and one in October, and one says 40,000 and the other says $54,000. The one that's itemized, the only time my client hears for the very first time that there's force-placed insurance is in a September notice of default. And in that September notice of default, which is my Exhibit F, it states this, that they're demanding immediate reimbursement of insurance premiums paid by the note holder in the amount of $1,132.68. So that's what my client is given notice of in September, before that October or November foreclosure. So that's what he hears for the very first time. Then we now have before the court an itemization on Exhibit D10, which is the defendant's exhibit, saying that my client owes $4,869. Where did that come from? That's brand new and after the fact. This statement is printed up on November the 15th after I filed the petition, and it increases threefold, more than threefold. There's great disparity.
What are you talking about, increasing threefold, the insurance?
Right. Well, we get a notice in September saying that there's $1,132 owed in insurance premiums. And then after we file suit, we get this exhibit filed that says, oh, it's not $1,130. It's $4,869 that you owe in force-placed insurance. And then the only insurance that was agreed upon by the parties at mediation was liability insurance. Why? because the land itself, and my exhibit E shows that the tax valuation on the land itself, which requires no insurance, just the raw land, is $196,000 valuation. That's 4 times the amount of the loan. They're 4 times.
Well, but look, Mr. Nunez, I understand what you're saying, but to a certain degree and to a certain extent, there is contractual relationship here. And, you know, we have to make reference to the agreement. Now, I'm gravitating, I want to read the opinion, this case that Mr. Izaguirre has quoted as being totally relevant to this proceedings and about the equity bill. But here's where I'm going, and here's where I'm understanding that the confusion not only is with the amount of the insurance, as you stated, Mr. Nunez, right now in that example, from September to November, it's jumped 4-fold, you know, in that given amount of time. So it makes it very difficult to tender something you don't know what it is, right? I want to read that case. Mr. Izaguirre,
Yes, sir.
have you sent it to me already?
I'm getting my secretary to e-file it right now, Your Honor.
Okay.
Or is there?
Yeah. How many witnesses are we going to need here to do this?
I would suggest doing it by
I mean,
proxy.
I have the exhibits, and do any of you have any specific objections to each other's exhibits?
Yeah, I was going to offer, because we're talking about all these exhibits, Your Honor. I was going to offer exhibits D1 through D10.
And I'd like to offer my pre-filed exhibits A through H inclusive. And if we can do that by stipulation, I think we can.
Well, that's what I'm asking you right now. If any of you have any objections to any specific each other's exhibits, if not, then the court will rule accordingly.
I don't have any objections to his exhibits, Your Honor. Just kind of arguments against them, but no objection to
the same announcement, Judge.
All right, then they will be admitted, subject to arguments against them. So the reason I ask is because I'm getting ready to do my criminal docket. I can bring you back here at 10 and we can conclude this matter. Is that okay?
I think yes, sir.
All right, let me do that. Let me go move on to my criminal docket, and then I'll come back at 10 and take care of this.
Okay, thank you, Your Honor.
Mr. Izaguirre and Mr. Nunez, did y'all file your exhibits with the court reporter?
They were filed.
You did? I didn't receive an email with either exhibits.
Oh, wait, they were filed way back in.
Yeah, I know. You still need to send them to the court reporter because I don't get those e-files.
Oh,
how do I do that?
It just reply to the Zoom invite. That's my email address. The CARRACE24@yahoo.com.
And I can email them there?
Yes.
Okay, thank you.
Thank you. Sorry
Thank you. It's okay. Thank you.
So Cindy,
Yes, sir.
we're gonna have jail docket?
This morning.
Yes.
Miss Guadalupe Sanchez?
How many?
There's
Miss Sanchez, and where is Miss Sanchez?
two. Because one is when I
Here in her
started.
office on another computer, Your Honor. Okay, is she on, Carolina? I don't see her on the screen.
Sorry for that. I've got Judge Oresi on the other one.
It's okay. I don't know if any of them are going to need an interpreter, though.
How many do you have? 2 or 3?
We have 3, but one is an absconder, so we don't
So we
know if
have
he'll
2.
show up. Yeah, basically 2.
Oh, okay. I'll be, if for any reason I don't respond when you say I need an interpreter, it's because I'm interpreting for Judge Oresi.
Okay,
In the 107th. Thank you so much.
Yes.
Thank you.
Uh-huh.
Is that correct? Yes, Your Honor.
Miss Fernanda Sosa. Miss Fernanda Sosa. Ms. Sosa, are you on the screen?
That's the one we did, right? That divorce?
Yeah, but she just joined right now. Fernanda Sosa? Ms. Sosa? I don't know. Ms. Sosa?
Yes.
Yes, your case was already handled this morning.
Oh, okay. Okay. Thank you.
It's already been finalized. You can log off already.
Oh, okay. Thank you.
You're welcome. The person listed as iPhone X, what is your name? Hello, iPhone X. What is your?
Ashley Moniz.
Okay, thank you.
Mhm.
Okay, what do we have on the? All right, good morning, everyone. I'll call the criminal docket set for this morning, starting with 2013 DCR 2751, Ashley Nicole Muniz. Ms. Barbosa,
Good morning, Your Honor.
morning. What's going on with this?
I believe the adjudication was based on 5 failures to report and arrears. I had spoken to Ms. Muniz and she was trying to make some payments and working with her probation officer, Your Honor. But she has not reoffended and she's been on probation since 2013. Just informed me that she's a single mother and she has no other source of income other than what she's doing for a living and taking care of her child. There's no restitution, Your Honor. All of this is arrears based on probationary fees and the fine.
Well, your client is inquiring about jail time. Why does she want a jail time?
Well, Your Honor, she didn't see any other way to pay off the fines. I don't know what the court can do, or we're asking the court for any assistance. Obviously, we don't want to send her to prison, especially since she's the only one taking care of her child and she hasn't reoffended.
Who's your probation officer? Probation officer for Ms. Jimenez.
Yes, Your Honor.
What's going on with this from your perspective?
Well, Your Honor, Ms. Muniz is just back to court based on fees. And I know that she was employed. She made little efforts to pay, her pending fees. I offered her an extension. She doesn't want to be on probation anymore. So the only way out is just go to you and see what you want to do with this case, Your Honor.
Well, I wasn't the judge in this case when I guess she was placed on probation, or was I?
No,
Your Honor.
So I'm not familiar with what's going on here. It's a second aggravated assault causing Mr. Janice or Ms. Jimenez. Can you enlighten me a little bit on the background of the reason she's on probation for?
Okay, hold on, Your Honor.
What happened and why was she assessed a $1,000 fine?
Well, the problem was, marital problems. I think the husband was seeing somebody else, and there was a fight between her and the new, person in the relationship with the ex or husband.
And so she beat up the new love interest of her ex-husband. Is that what happened, or it was a fight and the other girl took the worst of it, or what?
Hold on, Your Honor. Let me
Okay.
go ahead and
Yes, please.
I don't want to lie to you. Let me go ahead and
I'm not familiar with any of this background.
yes. Let me go ahead and
Raise your right hand, Ms. Munoz.
Do you solemnly swear from the testimony you will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can put your hand down.
Your Honor.
Yes.
Okay, according to the PSI, Your Honor, the defendant accepted responsibility for this offense. She admitted to shooting a gun at the wheel of the vehicle, but denied pointing a gun to her ex or the victim, Ms. Flores. She claimed that she felt threatened by Mr. Molano's actions, which is the ex, and for a warning shot. In addition, she admitted driving 65 miles per hour to report the incident at the Santa Rosa Police Department. And I think she had the kids with her at that time of that incident. That's about it, Your Honor. No more information here.
When were the?
I'm sorry, Your Honor?
When did she stop reporting, and when were those 5 days?
Oh, it was throughout
5 months,
probation, Your
5
Honor.
times, I'm sorry, 5 times.
Let's see.
So, Ms. Jimenez, you want to go to jail for what? For the fines and the probation fee? Is that what you want?
Me, Your Honor?
No. Ms. Muñiz. No, Ms. Jimenez, we haven't gotten to that point yet.
I like her, but not that
But thank
much,
you for
Your Honor.
offering to serve the time for Ms. Muñiz. We appreciate that very much. Look, Ms. Muñiz, Why do you want jail time? To pay off what?
Sir, at the moment when I requested it, it's because I had quit my job due to certain reasons, and I had the time to be able to pay this off and clear it out. But now I'm working again, so I can't do the jail time. I was willing to do what I needed to get off of probation the day that it ended, and was here we are. The 5 times that I missed report is because I had to reschedule, so they were counted automatically as no shows. And I mean, I've been doing anything and everything I can to stay out of trouble. I should have never gotten in trouble in the first place.
Well, let's not go revisit that, right? Because that's behind you, isn't it?
Of course it is. And the thing is, I got in trouble.
And that individual that caused you to get so angry that you lost your cool and your head is out of your life. Is that correct?
Yes.
Well, that's a good thing. That's a good thing, isn't it?
Yes, it is.
All right. So, well, listen here. I need to have you to comply with what I'm asking you to do. Look, we can look back at it and whatever circumstances drove you to whatever you had to do or do at that time you felt you needed to do or you couldn't control, whatever it was. The fact of the matter is, like a famous philosopher would say, just think, no matter where you want to be, there you are.
Yeah.
Understand what I'm saying?
Of course.
You're here. No matter where you want to be, no matter how many you wish you hadn't happened, you weren't here. But just think, there you are. Here we are, and here we are. And so you're subject to my conditions of probation. I am glad. I'm happy to see that in your report that you have not reoffended. That is a positive thing. So you've got positive things going in your reporting, but you need to carry through with what you promised a long time ago to do, is obey and observe each one of his probation. If you had done that to now, you may not have been in probation, but you have delayed it through your actions and non-compliance of things that you minimize, whether it's not that important or no, I don't have to. And here you are still on probation when you could have been off of it a long time ago. So
when this first
for our bottom line is everything has been in your hands, Ms. Muniz. Your freedom has been totally in your hands, not in mine.
Of course.
And so you need to show me that you appreciate that freedom, that you really like being outside. You really like being able to hold a job and go to a job and take care of your kids and do your responsibilities every day and day in and day out. That you really do appreciate that, and you do it by complying.
When I got in trouble, I wasn't working. I wasn't doing anything. So it's kind of been rough, but I've been trying to do what I can to get out of it already. Like I said, I should have never been placed on it. So I've been doing what I can. All my classes, everything I needed to do was completed. The only thing is the fines, and only because, like I said, like I'm a single mom.
I'll tell you what, I am not an individual who is a stickler for some of these things, because I feel that there's more important things. If you, in fact, appears to be that your life is straightened out, that you've moved on from this terrible incident in your life, then I want to help you. I want to be a willing partner, but you got to help me back.
Of course. Yes.
You understand what? Are you taking my hand and my offer of help? Are you taking that?
Yes, sir.
All right then. Well, you help me in return, and I'll take your offer of help, and you do what I ask you to do.
Okay.
I'm gonna reset this whole thing. You look at here. You start straightening out some of these matters, Ms. Muñiz, as best as you can. Show some promise. Show some commitment to it. I may look on you favorably next time you're in court, but you got to show me some love. Do you understand me?
Okay.
Okay. All right. So I'll reset this for 6 months.
6 months?
Yes.
Okay.
See how Ms. Muñiz is doing that. Hopefully your life will continue to improve, Ms. Muñiz.
So what do I have to do, sir? Do I have to pay, or because
as best as you can address the arrearages you're at. Yes, as best as you can.
June 24th, Judge. June 24th.
June 24th. Let's see how you're doing by June 24th.
Okay.
All right.
Your Honor, will she be needing to make more probationary fees for these new months?
Whatever it takes. I mean, I will do this much for the remainder part of the probation. Court will willing to consider reducing your probation fee to instead of $60 to $40. Help you out with 20, okay? But you need to show me again. You need to show me some commitment to this, Ms. Muniz. This is not a one-way street kind of a process or relationship. It's a two-way street. I drive your way, you drive my way. Do you understand that?
I understand. It's just hard.
I know. Life is very difficult, throw you some very difficult curve, but you're almost there and you're almost at the end. Let's get you there. So you put this totally behind you. Okay?
Okay.
All right, man. We'll see you June 24th. Write that down. Make sure you're here, okay?
Okay, thank you.
Thank you.
Thank you, Your Honor. I believe that concludes my business for this most honorable court. May be excused.
You have a good day, Miss.
Thank you, Your Honor. You too. Bye-bye.
2012 DCR 612, State of Texas, Omar Saldivar. Mr. Rivera.
He's in the courtroom. Let me see. Judge, he's here.
Okay. Mr. Rivera.
Yes, sir.
I am going to, where's the probation officer on this one?
Right here, Your Honor, Ms. Cervantes with the probation.
Do you have any objections to letting Mr. Rivera go?
No, Your Honor, the motion was basically on arrears and he has liquidated them and his probation term has officially expired.
All right. Mr. Rivera, thank you so much for cleaning up the last portions of this probation and taking care of it. You did a great job. Appreciate it. Staying out of trouble, taking care of all my classes, and you're now free to go. You're released from total any and all responsibility to this court. And have a great day, sir. And be careful and don't come back. There's nothing good here, Mr. Rivera.
There's nothing but quarantine right now.
That's right. You have a good day, sir.
His name is Mr. Saldivar.
Yes.
Yes, I was going to bring that. It's Mr. Saldivar.
Mr. Saldivar, I just let go of my bailiff.
I know.
Hey, you go too,
have a good day, Mr.
Your
Rivera.
Honor, are we denying the motion?
We're denying the motion and we're letting Mr. Saldivar go.
Yes, sir.
Awesome. Thank you so much, Judge.
Do I need any,
Have a good
do I need
day.
any paperwork?
Yes, sir.
Do I need any paperwork?
No, you don't report anymore. Your case will be closed and that's it. Forget you ever saw this place.
8 years going by so quick, huh?
All right, sir. Have a good day.
Thank you. Cervantes, thank you very much.
You're welcome.
Thank you. That's all I have, Judge. May I be excused?
Thank you. That was a good one.
All right, man, you too. Take care.
All right. 2017 DCR 1830, State of Texas, Guillermo Gonzalez Torres.
Your Honor, he was called 3 times and there was no answer.
What says the state?
State has the case be issued bond be forfeited, bond be such a no bond and judgment nice have issued in favor of the state.
That will be granted. Ms. Castillo, you okay over there?
Yes, Your Honor.
Okay, because your camera's all over the place and I'm going, okay, she's giving us a tour of her office and the paperwork. And her camera fell down. All right, do I have anything else? I mean, other than Carlos Aguirre and Mr. Nunez.
Right, that's the only one.
Okay, what time is it? I told him I'd be back at 10. If we can get him back now.
Want me to call him, Judge?
Mr. Seguin is on the screen.
I'm here, Your Honor.
Mr. Nunez.
Yeah,
I
we can
don't see
get-
my client.
If we can get Mr. Nunez, we can start earlier. I just finished my criminal. Oh, there he is.
I'm here, Judge.
Uh,
My client's not with me, but I think.
have you all properly served copies of your exhibits to my court reporter?
Only Mr. Seguin.
I sent them, Your Honor.
I did just moments ago.
Okay, I haven't received it yet, Mr. Nunez. Maybe it'll come in right now.
Let me wait for those exhibits to officially be in here. Did you send them right now, Mr. Nunez?
I did, and I'm going to send it again.
Okay.
Because things happen.
I know. Trust me. Estella always has to resend her emails for some reason.
Hilda?
Yes, Alejandro. Mr. Nunez, you do need an interpreter for your client, correct?
Yes, when he comes back, he stepped out of my office just for a moment. I thought it was going to be 10 o'clock, so we may be able to proceed with.
Are you still in another court, Alejandro?
Yes.
Are you on another
Okay.
call, Mr. Nunez?
No, I'm not. I'm all yours.
It's Alejandro, the interpreter. He's in the 107th as well.
Hilda and Nathan, we're done. Nathan?
Thank you so much.
Yeah, that other guy is in quarantine, okay?
Okay,
Good
I'm having
morning,
computer issues, so I'm using my phone, but thank you.
Okay, okay. Rolando, you're dismissed.
Thank you. Have a good day.
Okay, bye-bye.
Like at this gig, like early?
Miss Norma,
Yes,
good morning. This is Hilda. I heard you said that I was dismissed.
yes.
Okay, and George Rodriguez, was he reset?
I reset him for next Tuesday. Let's see if he's out of quarantine. He's been in quarantine since last week and then again today, so,
Okay, so for next Tuesday.
yes.
Okay, sounds good. Thank you.
Okay.
Have a great day.
Okay,
Thanks.
bye-bye.
Thanks, bye.
Norma, have you already reset them or do you want me to do it?
The reset
The
them?
reset. or
Yeah,
the-
I already reset him.
Okay.
I just
Hey,
need to
Luke.
get hold of Dan on one for tomorrow.
I can't send that.
Okay.
You can, yeah, I haven't received your email. Let me see if Brenda's gotten the exhibit.
No, I see it's not going out. There's a problem. Let's see.
Let me see if Brenda got them. You e-filed them correct a while back?
On November 15th, I e-filed it.
Okay, let me see.
Have you understood all of the questions that were asked to you by your counsel, Mr. Cisneros? Yes. Have you understood all
Might
of
be
my
too big a
questions?
file is what's going on.
Yes.
Let me see if I can. Oh, I just heard it go through. Yeah. It went through. Hey, Cindy?
Yes, yes, sir.
It went through.
Okay.
I heard
Are
the,
your exhibits attached to your petition? Also?
no,
No,
not
they're
all.
not.
There are some, but not all.
Okay,
But the itemized exhibit list, I think just went through on 925.
let me check. Hold on.
Now, this accident did occur 2 years ago, November 29th. At the time of the accident, not only did she sustain physical injuries, there was some ongoing emotional concerns that I discussed with her mother on Saturday regarding.
Yes, I got it, Mr. Nunez.
Okay, that was a resend, by the way. The other one, I don't know what happened to it. But,
Okay, maybe it'll come in later.
okay, yeah. I heard the whoosh on this one about 2-3 minutes after I sent it. Anyway, thank you.
You're welcome.
As time has gone on, she has recovered well, been better in school, she's starting to get back in activities and get back to living normally post-accident. So physical injury, she's recovered well. Emotionally, it's a work in progress, but she is doing well. I did discuss the settlement figures and the fact that the money would be deposited to the registry of the court. Her mom does understand that. She's in agreement with that. I did review the figures. They are exactly correct. This Mr. Cisneros read them into the record. And the mom knows that she can petition the court if she needs anything from me prior to her turning 18. I did explain to her she does not have access to the money if she needed anything for something that me and my prior to her turning 18, she would have to go back to the court to petition that money. All of that being said, Your Honor, she agreed, she understood everything, she agreed to everything. She did feel that it was in the best interest of her daughter. And my report to the court is that I do believe that the settlement agreement is in the best interest of the minor child as it is read into the record. And I would ask the court to approve the settlement.
Okay, anything else?
I've discussed my light of fee with Ms. Bella, and it has been agreed to, and I believe we will do that in the final document.
Oh, okay, Judge. Okay, yeah, I was gonna ask you that. All right, the court will approve the friendly suit be granted and granted to be the business of the town. Anything else? Hey, Mr. Vela, you need something on that wall back there?
I'm working on it, Judge.
I can lend you a picture. Okay, thank you very much.
Thank you, Judge. Number 11, Judge, please.
Number 11. Did we already call that?
Yes. And we're supposed to go to the rental room, but they got.
Oh, yeah. 22 DCL 202, Zavala.
Morning, Judge. We have Mr. Vasquez, Judge. We are the movies.
Okay. What's the status of this PRO?
I did have an opportunity to talk with the mom and some other. It's profane.
Yeah.
And it's one good. We have one unresolved issue. I think everything else we're able to resolve. Just one thing, Judge, which is the geographic restriction.
Okay, you're asking for a geographical restriction in Tarrant County?
Yes, Judge.
And is it against
Mr. Alamis?
Ready, Miss Cindy?
Yeah, I'm here.
Okay. Let's get back on the record in Margarita Osuna versus Adelante Funding et al. Sure. Mr. Aguirre.
Yes, sir.
Ginter Davis copy. Thank you for that.
Yes, sir.
I was reading that a little bit, and also I have your brief concerning the novation issue that you mentioned in your earlier presentation. Mr. Nunez said you filed a corresponding response to this, to the brief concerning innovation that Mr. Aguirre filed with the court.
I have not. I just received it moments ago, Your Honor.
When did he file it?
I just filed it.
Oh,
while we were in the hearing.
After the hearing commenced, Your Honor.
Seems to me that since we've admitted all the exhibits, that the court can review the exhibits with the intentions of each parties in mind as to what I'm looking at. Reading the brief that's been filed, the case that's been filed, and any other briefs that Mr. Nunez would file, and allow the court to make let me ask you, Mr. Aguirre, one point. As far as I've read, as far as I could read in the case that you're talking about, Ginter Davis, You cite that case for the proposition that in order for equity to be made, there's got to be some kind of good faith tender from the debtor, either in this case, a tender of the tax amounts that the lender advanced, or if not the insurance, forced insurance premiums, at least the taxes that were incurred, because those are unquestioned. They were assessed by the county and they were paid by your client. Is that correct?
Yes, Your Honor, that's basically it.
But and that's what the Ginther case would show me, that in order to get equity, you got to do equity.
Correct, Judge.
Basically. Okay.
Yes, sir.
Mr. Nunez?
Your Honor, I'll distinguish that that case law and differentiate it, because
as far as the facts, as I read it, they're not on all four in this case. I mean, they're not similar to this case.
And then the other difference is the closing salvo in this case, the very last paragraph, it says appellants have failed to establish that their legal remedies against the bank are inadequate. Although they allege that the property is unique, they don't explain how this is so. Their objective is to sell it and not preserve it. The difference here is that we have a homestead. That's what's alleged in the sworn petition. It states that this has been the homestead of the plaintiffs for 32 years. And that was the basis of the initial lawsuit, that this was a homestead. Instead of it being a home equity loan, it was a commercial loan that was made on this homestead property. And that was the basis of the settlement, where the balance went from 200,000 to 50,000, more or less. So that's what we have. And look, to throw one more monkey wrench into this, there was a loan modification, and I'll rely on opposing counsel's argument with regard to novation, but the original documents survive, and still we don't have a home equity loan in place. We have still a commercial loan, and I mean, this is a snafu deluxe, because we don't have a home equity loan, but this is a homestead.
Your Honor, I have to object to him continually bringing up this issue of the home equity nonsense. That was a completely different lawsuit, and it was settled.
Right, but we're using the same documents.
And if you look at the Ginther, Dave, the homestead issue is a red herring. I mean, it has nothing to do with whether the taxes have been paid or not. The Ginther Davis opinion clearly says the taxes have to be paid first. Doesn't say only if it's commercial loan or except if it's a homestead. There's no talk about that. So that has nothing to do with this.
It has everything to do with how they go about foreclosing, because if it's a home equity loan, then they've got to do a 736 proceeding.
But it's not a home equity loan.
Well, there you go.
That's the allegation in our petition and the basis of the settled suit.
It can't be a home equity loan. If you look at the loan documents, they're clearly not. It's not a home equity loan.
Oh, that doesn't determine whether it's a home equity loan. What determines it is if this is the residence and domicile of the plaintiff, and we've always alleged since the filing of the previous lawsuit, but we certainly.
Well, Mr. Nunez, then you shouldn't have settled the case, and you shouldn't have prepared the loan modification agreement that you did.
Well, you all shouldn't have agreed to it. You agreed again to an illegal contract.
Okay, well, there you go. Well, you shouldn't have either. Well, let me ask you both. Assuming that all this temporary injunction goes by the wayside and it's granted and we get to a hearing, what is the issue is going to be? What how much? What is exactly owed to you to Mr. Azeguera's client, or what?
That's it. It's going to be an accounting issue.
Well, that's what it sounds like to me. I mean, if I could take Mr. Because of my ignorance in accounting principles, I would like to take Mr. Azeguera's contention that, you know, the numbers are solid and we'll just run with that. But then again, we can't, because you were disputing that those are the correct, in light of the invoices you received in September and November of this year that are contradictory, or that they appear to be way high over the amounts that were previously stated as owed, right?
There's a real accounting issue. I mean, one month it's 40,000, the next month it's 54,000. And then we have the issue of the insurance, which is not an insignificant amount, because we've only got a $40,000 loan, and we've got now an allegation of $4,800, more than 10% of the total principal that's alleged to be due in insurance that I don't think is owed at all.
Your Honor, the other thing, though, I just wanted to point out about this alleged discrepancy, I really don't think there is one. If you look at Plaintiff's Exhibit C and you compare it with Plaintiff's Exhibit D, I think that's where Mr. Nunez's confusion is coming from. Exhibit C does state that the amount of the debt is $40,723. And then Exhibit D, which
it's Exhibit F that I was referring to.
Yeah, I'm sorry. Yeah, you're right. Exhibit F. You compare C and F.
Right.
So those amounts are different. But the reason they're different, Your Honor, is if you look at the October 8th, which is Exhibit C demand letter, it says $40,723.98 plus attorney's fees, interest, and expenses. So those attorney's fees, interest, and expenses are not itemized in this particular demand letter like they are in the other demand. So that's where I think that's where the discrepancy is coming from. It's not really an accounting issue.
Well, if that's true, Mr. Seguirre, well, then your notice letter is defective.
The notice letter is not defective, Your Honor, just because
if those expenses and charges are not itemized, why seem to
those initial default letters, Judge, or notice of intent to accelerate, is basically saying, here's the amount of principal that's owed. There's also fees and interest and expenses that are owed on top of that.
Right.
The lender is giving you this notice of its intent to accelerate the maturity of the debt if you don't pay all these amounts due. Oh, and by the way, it says in the letter, if you want to pay this off and to avoid acceleration, contact the lender so that we can provide you with the payoff amount that you need to pay to avoid acceleration. It's just giving the debtor notice that there is a default. You need to contact us to figure out how to remedy that default, how to clear that default.
Let me explain why that's not the case at all. It's in September that the amount allegedly due is $54,000. The next month in October, the amount goes down to $40,000. So it's not something that's added later. The $54,000 amount
they've reduced the balance by 14,000 somehow or other.
That's right. It's not something that was added later. Some attorney's fees or expenses. No, it's 54,000 on September, and then October it goes to 40,000.
The raw principal was $14,000 higher in September.
Yes.
Without reference to any expenses, added fees, all that, the raw principal was 54,000 in September, and it turns out to be 40,000 in November. What's the contention regarding those amounts?
I don't understand why they're complaining that we're reducing the amount that they owe. If they want us to go with the higher amount, we'll go with that.
I'm complaining that they don't even know.
If it was that dry, Mr. Aguirre, I'd reach it to the screen and slap Mr. Nunez. Give him one. You know? I don't think it's that dry. You know, that's a complaint. The complaint is confusion onto your amount, your own paperwork, and that's been thrown off. All these amounts and. One of them you justify pretty good that, well, it includes all this stuff. Well, that may be so, but what do you say about the other one? So seems to me that this case is going to be driven by a accounting nightmare because if you're in fact those numbers are way off or they're inconsistent or they are just very confusing, the court can exercise equity to enjoin until you have a final trial in this matter. But I will tell you right now, because of the number games that I'm not very good at, I am going to probably need to lean on somebody to help me run through these numbers. and the exhibits that you both have submitted to figure out how to make sure that we, in light of the explanation given by Mr. Zaguirre regarding the note structure and regarding the explanation Mr. Nunez has given me regarding the confusion in that structure.
And I'm sorry to interrupt, Your Honor. I'm just wanted to point out that I'm not a lender. I don't do this, so I don't know exactly what I'm talking about. I'm just the attorney for the lender, but they use software for running these notes and keeping track of everything. So I would imagine that just with the few reports, they can spit out the loan history and show each and every payment that's been made and the balance and all of that. So I don't think it's going to be the accounting nightmare that we're talking about. I think it's going to be a relatively simple process to figure out.
Mr. Nunez, if you are given the opportunity to review that, so I think I agree. If you have a computer generated QuickBooks, so to speak, where it shows you the balance as of whatever date, and then here's what was applied to it, and here's what we added to insurance, and here's whatever, and gives you that kind of accounting. That would kind of go a long way to straighten this thing out, wouldn't it, Mr. Nunez?
I think it would. I think we can.
Mr. Zaguirre, are you willing? Have you provided that information? And if not, are you willing to do it?
I'm willing to do whatever it takes to get this matter resolved, Judge.
Okay.
I think.
Mr. Nunez, what information, reasonable information? I don't want you to go back to the history so that you unconfuse yourself when this problem started. How much information do you need in that regard?
This was just a 48-month loan, and we're at the end of the term. It was last year, mid-year, when the 48th month came and went. So it's just a matter of producing some documents. I've made an informal request for the insurance that was in place and the actual premiums that were paid on behalf of my client for the forced placed insurance, but have been unable to get that documentation. It's not an insignificant amount on a $41,000 payoff. It's almost $5,000. So that's something that needs to be hashed out. And the only thing that an accountant wouldn't be able to figure out, with regard to that, whether it's due or not. And so that's an issue. But Judge, it's our position that with regard to the temporary injunction, that we have shown that there is an absolute steadfast and firm basis for that temporary injunction while this matter is resolved. And
here's what the court feeling. The court's feeling about this is basically the court is very keen to foreclosure on homesteads, regardless of what you call it. I don't think that a lifetime of work should be, if it can be salvaged, it can be salvaged. An opportunity should be given to salvage that. But the fact of the matter is, also staring is the obligation and the rights of the debtor to enforce his debt properly. So yeah, I don't have any issue with doing that as long as the court is satisfied that all the numbers that this thing should be it shouldn't be as confusing as it sounds, and hopefully it's not. But the court exercising equity because of the confusion in the numbers, and particularly this last numbers we talked about, 54,000 in September and 40,000 in November, they went down. That's kind of confusing to the court too. So the court would be inclined to do that, but I don't want to do that right now until we settle on some principles here that information, because I do not want to have this temporary injunction in place for a long time. I want to have it in an amount of time that is reasonable to exchange the proper documents that will reflect the nature and state of the account at any given moment during the life of this debt. Mr. Zaguirre has stated he has no issue with providing that to you, and we need to get that done. So, Mr. Zaguirre, I gotta lean on you. How long do you think it would take to give him an accounting of the nature, from the inception of this debt to currently? And show showing entries of, the assessments made for the forced insured and assessments made for the taxes, and in fact, that would, how it affected the balance that it kept rolling in terms of this thing, because at one point it has to affect it, so that would go a long ways. How long do you think you need?
I'll do it as quickly as I can, Your Honor. I can't speak for my client because I don't know if it's just a matter of punching a couple buttons in the software and it spits up the report, or if it's going to take, a little bit longer than that. But I would imagine, a week. And the reason I would ask for 2 weeks, but I'll try to get it to Mr. Nunez within a week.
Let's err on the side of caution, because look at here, we're in a COVID period of time, we're having to deal with it. It affects our business too, So why don't I, abundance of caution, we'll do it for 2 weeks. I'll give you plenty of time. And the status quo will remain until we conclude this matter in terms of that time. And it'll give me time to slowly read your case if you have, I've read some of it, but also read your brief and any other things that may be filed between now and then.
Yeah, and Your Honor, the only thing I would ask, and I appreciate the court already mentioned it, that Your Honor does not want a temporary injunction that's going to last for a long time. I do know that my client is, frustrated with the amount of taxes that they've had to pay without getting reimbursed. So, on one hand, I understand the court's desire to protect Mr. Osuna's alleged homestead, even though we're debating that, or his property or the equity that's in his property. But as the court correctly stated, the creditor has rights too, and contractually, Mr. Osuna's required to pay back at least the $30,000 in taxes that we've paid. So if we could, if you could have us back in a couple of weeks, I think that would be more than sufficient time for me to get, or whatever date you said, the information over to Mr. Nunez so we can try to figure this out.
Judge, our point is that there's no harm that's going to come to this defendant. This defendant is owed $41,000 according to their own payoff statement. That's Exhibit 10. And they are a lender. They make money off of lending money. They're accruing interest. My client's accruing an interest at 6%. They're earning an interest at 6%. They are abundantly secured. They are secured deluxe. On a $40,000, they're secured 10 times over. We've got a value.
I understand that, but look, that can't be a justification for default.
I understand. I'm just saying there's no harm in a temporary injunction, a brief delay because of.
And that's where I'm going, because that's the sentiments of the court, and that's why I expressed them earlier. But the court cannot ignore default. If it's default, it's default. So let's reset it for a couple of weeks, and I'll give an opportunity to look at some of the matters that have been filed today, along with the exhibits, and allow you an opportunity to exchange those documents that Mr. Zaguirre is going to provide to you, Mr. Nunez. And if for some reason there is a problem with that, you need to get back to the court, and we'll extend the time. In the meantime, the status quo will maintain until we have that hearing to decide based on the information we get. Okay?
Yes, Your Honor.
Okay, Ms. Salas.
That's good, Your Honor.
Ms. Salas.
Yes, sir.
2 weeks.
Okay, February 10th.
February 10th, gentlemen.
Thank you.
8 a.m., sir? Is that at 8 a.m., Judge?
Yes, sir.
Okay.
Yes, ma'am.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you.
May we be excused?
Yes, sir. Have a good day.
Okay, have a good week, Judge. Thank you.
Bye, Alejandro. Thank you so much.